Hi, I'm Jason Brand, staff attorney for the Maryland Association of Realtors, and I'm here to talk about the differences between mediation and arbitration. Mediation and arbitration are both types of alternative dispute resolution. Alternative dispute resolution is basically any procedure that settles a dispute without going to court and litigating that dispute in front of a judge or jury. So what exactly is mediation? Mediation is a process in which disputing parties attempt to resolve their disagreements with the help of a mediator, who is a trained, neutral third party. The mediator's function is not to pass judgment or render legally binding decisions. Instead, the mediator's function is to help the parties communicate their differences and assist the parties in creating their own solution. Where does mediation appear in a realtor's day-to-day affairs? The answer is under the MAR residential contract of sale. Under the contract, the buyer and the seller agree to mediate any disputes they may have that arise out of the contract before filing a lawsuit. Most of the time, this occurs when there is a dispute between the buyer and the seller as to who should receive the earnest money deposit when a property that is under contract does not settle. Mediation gives the buyer and the seller an opportunity to sit down face to face and tell their side of the story and, with the assistance of the mediator, focus on reaching an agreement that results in a win-win settlement the parties themselves have crafted. Arbitration is an entirely different animal. Unlike mediation, where the parties themselves decide if or how the dispute will be resolved, arbitration requires the disputing parties to hand over the power to decide the dispute to an arbitrator or a panel of arbitrators. In an arbitration hearing, the arbitrators may hear testimony and receive evidence from each party, and when the hearing's over, the arbitrators render a binding decision where one party wins and one party loses. As realtors, brokers agree as part of their realtor membership to arbitrate disputes over money with other realtor brokers. Nevertheless, brokers are given the opportunity, or in some cases are required, to mediate their dispute before the case proceeds to an arbitration hearing at the local board. So, what are some of the differences between arbitration and mediation? For one, mediation is typically faster than arbitration. As a general rule, mediation only takes about 30 to 60 days from beginning to end. Next, mediation is generally less expensive than arbitration. Finally, mediation may maintain or even improve relationships between the disputing parties. This way, the parties are able to talk and work out a mutually acceptable solution, while arbitration may diminish the relationship between the parties because only one of them walks away a winner. For more information on mediation and arbitration, check out mdrealtor.org and click on the Code of Ethics Professionalism tab. On behalf of the Maryland Association of Realtors, thanks for watching.